Welcome back. My guest is a legal practitioner, he's a lawyer, barrister of the Supreme Court, solicitor of the Supreme Court, a human rights advocate, a negotiator, and a public affairs analyst. Enyete Bassey, welcome to Political Spectrum.
My pleasures. Thank you for this invite.
Good to see you. So, let's start with the elephant in the room. It seems as if, 16 years has been quite a long time in having the judiciary's salaries reviewed. But looking at this in the backdrop of where we're coming from, just concluded elections, last year's elections, and the litigations that followed it, and they're not so, some people say they weren't happy with how it ended. And then Labour went on their actions and they saw their pay rise. It seems as if it's payday for everyone, particularly this time the judiciary.
Well, I won't jump into that bandwagon to say that it's a payday for everybody, because the entitlement of these institutions was long overdue for increments. So it's not that they are not deserving. I think it's just some political goodwill coming to the realization that it's high time those who work should earn a wage. Might be not just even adequate, because if you ask me, what Labour had at the end of the day wasn't what they asked for. And so the increment currently made or presently or just be made for judicial officers perhaps might not also be sufficient. But it's a leap in the right direction. I came to say thank you, Mr. President, for coming to the consciousness to, give this pay increment, because the expectation is that it would degenerate or generate into more improved areas in the judiciary. It's still a way of telling the judicial officers, you are independent, we need you to have your finances. You can't expect a judge, for instance, in Akwa Ibom State, there are a lot of judicial officers who are expecting a good environment to operate. You get it, good motors to go to work, good staffing. And so when this pay is not available, or you're not even paid, for instance, they are buying the same market we are buying. Yeah. We are having high inflations all around our economy. And so you expect them with paltry sum to survive through. So in order to tell them, please be mindful of your, because it's a specialist area of services rendered to the society, they need to be given more money so that recently, they were rated, judiciary is rated, I think, number 2 in corruption profile or index. Yes, what would necessarily push someone to get corrupted or get bribed? I think it's lack of proper pay.
That could be one of them, because we don't have evidence that in all of the best paying places that we don't have corruption either.
So when you look at the index, you will see that these guys may be tempted, because what I take home isn't even enough to take care of myself, talk less of my family. I may be tempted. Also, it's high time they too sit up. Government is doing a bid to ensure that you receive a pay that is commensurate, at least, to your services that is expected. So I don't know what the complaints will be, because assuming, though not conceding that a little pay was the reason for becoming number 2 in the index of most corrupt institution. Now that their pay has been increased, I think it will be reason of, look back.
Whether there will be a scale down.
There should be a scale down.
Fair point. But then take a look at it now. Why is it that former government or former dispensations didn't seem it fit to do this? What do you think is responsible for that?
Okay. I think I would give this kudos to President Bola Ahmed Tinubu. ABC is antecedent. He has been a people's person. He has been the grassroots person. And so this is a style of administration, realizing that it's high time I came down to make sure that whatever is necessary is done. What's the essence of government? What's the essence of government? Government is to exist. Government exists to ensure that the glamour from the people are taken care of. Because we are supposed to go together. So it's about that sense of empathy, to realizing that the people are in need of this because they are even deserving. There's a legitimate expectation from the electorate that the government would meet their needs and aspirations. So I think Tinubu understands the nuances of what is the basics to have a community of people who are conscious followers. So that makes him different from previous administrations. There were protests, there were strike actions from labor, but with little succor coming from government before now. So it's not that he is weak. No, he's not weak, but he's being sensitive because that's an expectation. That's a character of a government that we need in the modern time. So I'm chalking it up to the fact that it's about being conscious to ensuring that it's not a case of monkey the walk, baboon the chop.
I didn't want to push you on Buhari because that's Tinubu rather, because that's not our emphasis today.
Yeah.
We're looking at the judiciary. But when you talk about sensitivity, what would argue against that, particularly when you look at the manner in which this entire hardship, the way it's playing out, came up? Mr. President, I don't know how he arrived at that policy directive, or direction rather, came up with end subsidy immediately. It was supposed to, by the way, all political party presidential candidates said they were going to end subsidy. Everybody had a consensus on that. Yes. But the approach was different. Others said they were going to take some time off, they had a plan. But it seems as if Mr. President didn't have a plan. It just came yanked off the subsidy. Some would say because the state of the Nigerian economy needed drastic measures. We were owing close to over $100 billion. Yeah. So those arguments. But then again, I wouldn't particularly call him feeling the pulse of the people while implementing these very far-reaching policies.
Okay. I think Roosevelt once said that we should know that two people may think differently, but they are correct. So I did come to differ your perspective to the effect that Mr. President might not have done sufficient homework about what would be the effect, what would be the implication of removal of fuel subsidy on the very first day in office. I have spoken on this on other forums that the mechanism needs to have been set in place to ensure that it cushions the effect, because we know the Nigerian society we live in. Immediately it was announced that fuel subsidy was removed. The marketers who had petroleum products at a very low rate, increased it astronomically. And that's what we are suffering today. I know that in Uyo we are having fuel at about 900
plus, 920.
You get it. So I won't, in this perspective, say that Mr. President had taken stock of what would be the aftermath of removing fuel subsidy from the very first day in office. But about fuel subsidy removal, it became imminent that we needed to do this. So, but if you look into it and say, what ought to have been done before the removal of fuel subsidy? Government needed to have made provisions for proper importation of fuel, or you negotiate. After all, we have refineries that have been in comatose, and year in, year out, billions of dollars are reeled in for turnover maintenance.
We're going to come back to that refinery.
Let me land this thought.
Okay, go ahead.
So for those who would have said, other aspirants have said, I will take a little time before I remove subsidy. Might be their plans was to ensure that at least one or two refineries were operational. If these refineries were operational, we would not be having to sell our crude and then import refined products back. So it's like doing the same thing the same way and expecting a different answer. It's only a madman that does that. So unfortunately, we're still within that cycle of you sell the crude and then you import. And now government says no more subsidization of the products. That's what trunk us into where we are. It's a real plunge. And I don't know when we are soon getting out of it. After all, in your track here, a lot of issues. Dangote refinery. Not too long ago, we had heard about the refinery in Malta and who owns it. I don't know what the press is doing about it, but I'm only here to be asked questions, and I will answer the ones I can.
Like I said, we are going to move over to the oil and gas industry. But let's come back to the judiciary. You pointed out there, second most corrupt institution in Nigeria. By the way, some of this index is a global thing.
Yes.
And if you move over to the West, to the US, to almost across the world, you find that people have lost trust in government and public institutions. And for very correct reasons, particularly when you take a look at the criticism of this Chief Justice of the Federation, accusation of people bringing in their family members into the system, questions on whether those people pass through the proper channels, and some very, for lack of a better word, funny arrival at court decisions. Very funny. Again, we are talking about the judiciary. Where do you see us moving? Taking a track of, we have had some good, some pluses one can't deny. Again, look at what the judiciary has been doing. Take a look at the decision on the protest. We're going to come to that. But before this one, just a general overview of our judiciary.
Well, I must respectfully say that a few bad egg in the judiciary, because of landmark decisions that have been made, have sent dark signals into the judiciary, which ought to be the last hope of the common man.
But why should, why should we even have the judiciary be the last hope of the common man? Why shouldn't it be the legislature? Why shouldn't it be the executive, for instance?
Okay, beautiful. The essence of having a judiciary is that most often without conflict, not just most often, without conflict of interest, nobody would look for an adjudicator. So it's at that point that adjudicator comes as a third party to look into it. What is the standard of operation? What's the law? Are you right in your advocacy, or am I right in my advocacy? And the resolution comes, which we call justice, through the court. So the judiciary must exist. After all, we are in a democratic setting. The judiciary exists to ensure that justice is done as per the standards that are set. It is expected that they should be independent. It is expected that they should be impartial. These are core values that should, hold firm our judiciary. But in the recent past, we've seen basically our politics in this country has somersaulted in values and conventions, so that those who are qualified, the big chests, those who have more money, have found a way, the way and manner, to have their own perspective in issues come through. And the last place for resolution of these issues is always the court. And so don't forget that the judges, the justices are also people who are living in the society.
They are Nigerians.
They are Nigerians. So they have their interests. In jurisprudence of law, there's what we call the inarticulate major premises in every judgment. I grew up in a locality. There are certain preferences and opinions I would hold as an Etiabasi if I become a judge or a magistrate.
But shouldn't your training
I'm coming. Every case that comes to me, I already might have a prejudiced view about it because of who I am. Yes, it is expected that they should be apolitical. But they belong to a class of persons. They have friends. If you look through, behind the spectrum of each of those justices, there was a friendship that existed between the political office holder who is contending one election before their courts and them. And so these things plays out. That's why politically, if you ask me to make a division between what our courts have been able to do, between political decisions and every other decisions, I will tell you that we are still landmarking in every other situation apart from politics. Politics happens to be the substratum anywhere. So one decision given will go to condemn a great deal of other decisions. We have fine justices and judges that are still sitting and reading out judgment that are landmark. So I am not here to sit down and say that the judiciary is not doing its best. I started by saying that there are a few bad eggs. Like in every other institution, we have a few bad eggs. And when they give judgment, it influences a great deal of the entire spectrum. So that's the challenge we are having. And sitting down here is to encourage that as we are growing as a country, there should be a time that the real hope of the common man should not be truncated, because when we lack faith in the courts, that's the greatest lack. That's the greatest poverty. If our court no more holds that hope that it should give to the common man. Who is the common man of Mars? Who is the common man?
Who is the common man?
The common man is you and I. The common man is you and I. And the common man is the Nigerian people. So if we say the common man, we're also talking about the president as the common man. The president should have interests that should be defended by the court. So don't exclude him. All of us are common men. And so that's why the position of the judges and the justices are such high position. They are very sacred and ought at all times to be so maintained. The sanctimoniousness of our court ought not to be flushed under the political intentions of our politicians. It is expected that our court should sit back and call the politician to order. So that should be one big difference between the executive, the legislature, and the judiciary.
I'll ask you a quick one.
Please go ahead.
When you have situations where I love how you played it all from where they were nobodies and then they grew up to become justices and big politicians.
Yes.
But then when you have this flow into the family where you have a major politician is
Yes.
the spouse of
Yes.
a major officer of the law of
Yes.
the courts, shouldn't we have some mechanism,
Yeah,
legal
yes,
mechanism
we have.
that should say, for
We have.
instance, if
We have.
put me through it.
We have. The two prongs of justices says, Audi alterem patent. Nemo judex in calceswa. Audi alterem patent is listen to both sides before you give judgment. Nemo judex in calceswa is the doctrine that said, you shall not be a judge in your own case. So if your family member, your close friend is having issue, which matter comes before your court? It is a doctrine of the judiciary expecting that you should recuse yourself from it. You should not sit on it. But unfortunately, the society where we lived in, even when it is clamored by the press that a certain judge has a relationship whether business or by family bloodline with a certain person. Unfortunately, because we lost the integrity as a people, we begin to say, if it were you, would you recuse? That's what brings us to where we are. It is not that these laws and conventional practice are not in place. They are in place, but they need to be activated. It was a shocking incident that judgment was given in the final presidential election petition tribunal, and we didn't see the faces of those who presented the judgment.
I was going to come to that, but
So if you allow me,
we are here already.
Yes, let me say it is where I belong. I am a member in that. I'm an apostle in the temple of justice.
It's your constituency.
It's my constituent. It concerns me. So when these things happen, we begin to ask ourselves question. From here, where do we go to? It is a dark spot that we are in, I must tell you. But that hasn't deprived us the hope that there will be a moment where the bride can come. So there's a light at the end of the tunnel.
Is there I don't like to speculate, but is there a possibility that we could have people, particularly foreign interests, leaning on our judges and justices as they adjudicate on issues that have to do with the leadership of this country? Is there a possibility?
It will be maybe we're not be private to know, but speculations would have it settled that there could be foreign influence. I do not know, but just as I had said that there's something called inarticulate major premises, something that influences your action on a particular issue, whether foreign or internal. Judges are not expected to be so influenced if those influences are not positive. A kind that would unite us and bond us together and lead us to where we are expected to be, especially comparing Nigeria in the committee of other nations. If we call ourselves the giant of Africa, shouldn't we be the leaders in all spectrum where I think we should be? So when we talk about external or internal influence, you are committed. The oath of the office that they took, oath of judicial officers that they took, should at all times be the watchword and not who becomes who. Because we should always remember, every politician will live 4 or 8 years. Or if they are lucky in the legislature, they may stay 20, 22 years. They are not leaving what we call law report. Judicial precedent. Nobody would likely read it because the newspaper may be fished away or may wear out. But law report stays on.
And becomes a precedent.
And so when you make us proud, we'll begin to cite you like we'll cite Lord Denny. When Lord Denny was advocating for what we call judicial activism, he said if we fail to do what has never been done before, we would have gone nowhere. And the law would still be stagnant. And that would be the very bad for the law.
Talking about things like this, where we've never gone before.
Yes.
the local government tenure.
Autonomy and tenure.
What do you have to say with what some are saying that it seems as if the judiciary, the courts are making laws now?
Okay, so I would say yes, the courts are making laws.
So, what does the Constitution say about the tenure of the local government chairman?
Okay, so let me say this before I answer your question. There is what is called interpretation of the Constitution, which the court exists to do.
Yeah.
And we have different models or rules of interpretation
Yeah.
of the Constitution or statutes. One basically always shouted around is the literal interpretation, which the legislature most often expect the judiciary to do. Meaning you just look into the words of the documents and the dictionary meaning and implication they carry. You cannot go beyond the words of the Constitution. And it has been seen that this has promoted negativities and relied on too much technicalities. So in the course, because we are evolving, there is what is called purposive interpretation of the law. Purposive. Where the judiciary is allowed, because they live in the same society where we are. So look through to listen to the public glamour, public policy, public expectation, societal interest, and say, what do they really want? Can it be incorporated into this law? Because we cannot attribute sanctimonious reference or respect to lay lawmakers at the point when they were making the laws. A law is made far back in 1999. The Constitution, that's when it was last amended. And then if we trace back, we'll see that these laws were handed over unto us at the position of transition into democracy. And it was done by very few hands. Basically, the military, who were not proficient
And
experts. They were.
Anyway, yeah.
So they handed over this document onto us, and we've been gambling with it. So the document, over time now, has realized even its lacunas. There has been white papers submitted. The conference, national conference that was held in 2014,
Yeah.
had a lot to do with local government autonomy, state security, issue of referendum, and the likes. So when the court, having been faced by this present situation, looking into it to interpret the Constitution, they relied on what we call purposive interpretation, which allows them to look far beyond and doing justice based on interests of the moment than on technicalities. So if you ask me, is the tenure mentioned in the Constitution? I will tell you no, sir. Because what the Constitution gave was making the local government an appendage, and there's no other word to describe it more than an appendage. Whereas we are supposed to operate a three-tier government, the executive, the federal government, the state and the local government. So if you're saying that it's going to be a third tier should also have the liberties, the independence, that the two orders are operating as executives. This is purposive reasoning by the court. Now, unfortunately, in Section 7 of the Constitution 1999 as amended, the powers to talk about functions and the state of affairs of the local government is handed over to the House of Assembly.
The State House of
Assemblies, which invariably is in the hand of the governors. So when you talk about tenure, it is the State House Assembly that would say, okay, we can even decide to give you 2 years.
Or 5.
We can even give you 5 years. And we can even decide that you are a caretaker. You get it? So we have been dabbling. So in the 774 local government of the entire federation, you have different templates being operated. And I think what the Supreme Court has just realized, having this opportunity to look back into this law, is, can't we salvage the situation for once to have a unified system of local government administration? And they came towards doing that. So case law are laws that are made through court interpretation of the laws that were made by the legislature. And they have the value and the binding effect of the law.
Now, let's jump a little bit to some other situation. We had this play out in the U.S., the so-called Roe versus Wade case on abortion. Now, but many years down the line,
yes,
we've seen a situation where the Supreme Court has reversed itself. So in Nigeria, what's to say that another Supreme Court Supreme Court will not reverse itself and say maybe we should subsume, because we have people who are calling for constitutional change that will have the system that we operate now subsuming some kind of regionalism. So what's to say that the Supreme Court won't come and reverse itself on that?
Well, Supreme Court have the right to reverse itself. But fortunately, I have not seen any purposive and positive laws that do not affect the people negatively being overruled. Overruling a particular precedent would be critical when you look back at it and say, were the men who did this more eccentric? Were they people? Did they have the people in their minds? If you look at the abortion law in the United States of America and see how their policy formations is moving on. You see the liberal state where the state cannot decide for you what you should do. You get it? But before now, it was a more religiously inclined court that says, no, you cannot do it. Abortion is sin. But now the state is saying abortion is not a sin. So we're not operating a sin.
So it's a health issue.
Yes, it's a health issue. It's a health liberty that I have. Myself should determine what is good for me. It's not a religious practice. That, likewise, they have given the right to those who are having different perspective about their sexual orientation. So it's about the time. I had said in the course of this discussion, as a society evolves, as a modern state evolves, what was can be and what is might not be. So that will influence the court. So it's about looking externally to looking into the society what is generally acceptable. Recall that what is a moral principle today might be moral tomorrow. So the court is a reflection of the people's aspiration and intention.
We have on our studio Anyetia Bassi, is a legal practitioner, a barrister of the Supreme Court, a human rights advocate, negotiator, and public affairs analyst. And we're looking at judicial political interventions, a bridge or an obstacle to nation building. Let's move on to what's been playing out in some of our houses of assembly. Take, for instance, Rivers State. We also had the Ondo, the Court of Appeal came up and said, look, that gentleman was deputy speaker, but he was removed illegally. Let's restore him. So, but then again, when you take a look at what's been playing out, whether it's in Kano, in Rivers, you have a situation where this court arrives at a conclusion that is absolutely different from the other court. And it's been wreaking havoc in people's perception of, I don't want to use the word intelligence of the judiciary, the coherence is a better word, of the judiciary.
Okay.
How did we get here? How did we get out of here? And what are the implications in our legal system?
Law generally is a social engineer.
Yeah.
I want that to sink in. It's a social engineer. There are social frictions here and there. Some of them completely political, some completely socio-political, some socio-economic issues. And there is no two cases that are completely the same, with same facts, time, and basis. None. So when you talk about the social intelligence, I would recall that intelligence will be my ability to adapt to a situation with the basic knowledge that I have to apply it. Our society needs to come up to the extent of realizing that those justices or judges who sit on each of these cases are not daft. They are exposed and they know completely the facts surrounding each of the cases that they are.
So what's the case now? Political interest?
This is a political interest matter. And if you look at it, he was sacked in 2020, the Deputy Speaker of Edo State House of Assembly. He was sacked in 2020. This is 2024. That case had been going on at the level of the High Court and then moved on an appeal. Today we're talking about that matter judgment being given. The intricacies in it, the parties involved, both the applicant and the defendant, they are aware of what has been going on. And the court finally says, what you did, for once the law expects that fair hearing is a fundamental right of every person. Whenever you deny a man fair hearing, whatever decision taken, whether the process was completely right or partially wrong. If it is established that it was denied fair hearing, it is like a card unwell packed. It will come crashing. So if you look into it, the court is not saying that time had not passed, but the court is saying that you had deprived a man a right to be fairly heard. You did not save him a copy of the petition or the communique and never allow him an opportunity to be heard when you sat in to impeach him. So that's why we say that fair hearing can be heard first at appeal in Supreme Court. We can commence a matter from magistrate court, here being the lowest in the prong, and then we move on to High Court, move on to a court of appeal, and for the first time in Supreme Court, if I can advocate and establish my matter that my client was unfairly heard or was deprived the opportunity to be heard before a decision was taken, or that the court at the lower state did not allow my client to be fairly heard, every decision that was taken in the ladder will come crumbling. And the society will be like, oh, why such judgment? Oh, such judgment became so necessary and imminent because someone was deprived a fundamental right, a constitutional right that says it should be heard. Recall the two pillars of justice. Audi alteram partem is a Latin maxim that says listen to both sides. And the other one says nemo judex, don't be a judge in your own cause. So, and then two, the principle of rule of law says that ubi jus, ubi remedium. Where there is a wrong, there must be a right. So the man was deprived his right to have completed his tenure as a deputy speaker.
So does it mean he's going to go back to become the deputy speaker of Ondo State?
So as long as that is not a declarative judgment, time had passed, that tenure had passed, it becomes a constitutional issue now. The tenure had passed, that was in the 9th Assembly. If I'm right?
Yeah.
So currently they are doing the 10th Assembly. He is not a member of the 10th Assembly. He never contested elections to go in there. So the only thing now available will be that this judgment can only earn him the pay that he deserved for the 4-year tenure that was truncated. But he would have ended up not being a member of that house.
So
again.
do you think that that was justice served?
Yeah, that justice has been served. In the circumstance, you know, when I try to distinguish between what is a political issue and every other matter, between you and I, if we have a landmark issue or contractual issues that takes us to court, the outcome would likely be different. It would not be of such magnitude and critical to call public concern. Simply because it's a former deputy or an impeached deputy House Assembly member is why we're discussing here. Because government is tenured, or political office is tenured. When you have injury, for instance, it's like a football game. It's meant to be played for 60 minutes, right?
Yeah,
Abi?
Yes.
90 minutes.
Yes.
So if, for instance, I have something in my eye that makes me stay out of the field for 70 minutes, and then by the time it's clear, I'm back to play. I'm going to play for only 10 minutes. Or perhaps I may not even be lucky to get back to the stage. Nobody will recall that match to be played because I was the captain. When time is past, time is past. He cannot be a part of the 10th Assembly. It's a clear matter. Not even the Supreme Court will be able to impose him because currently his constituency has a person
that they chose.
Yes.
We have a little more time, but so many things I want us to talk about. Quickly, what's playing out in River State? We have to talk about River State.
My friend will say this is an extreme quagmire. A lot of issues in River State that are very novel. Very novel.
Because on one hand, you have the governor with his issues with the House of Assembly. You also have, even in the APC, you also have those who are linked to our former governor Amechi and former governor Wike. And the courts are generating decisions left, right, center. What's playing out?
No, you will retract that word left, right, and center.
Okay.
The courts are giving judgment or making rulings.
But when we look when we look at these issues, you see two courts.
Yes.
At the same level sometimes, you see them arriving at absolutely different decisions. And then, again, we agree that they are not daft. They are not unintelligent. How come they are arriving at these kinds of decisions that are diametrically opposite to each other?
So the facts are different. The court operates by the processes that are filed before it by the parties who are before it. There's what we call affidavit evidence. You file as a petitioner or you file as a plaintiff, and your opposition file as a respondent, who have affidavit evidence, file before a court. The court would not call you again to come and ask you to say or begin to go around because it's a private matter. He looks into the affidavit evidence and give reasons because of what you ask. So if you look at it, for instance, you are the ousted APC chapter chairman, and I'm the incoming. You go to court to challenge my position. I'll go to court to challenge that you shouldn't challenge me. And if I have basics about the nomination, how I emerged through a process that can be clinically seen to have been abided by the party's constitution, what do you expect that court to do? Give judgment in my favor and same in your favor. What we should be mindful now is who goes to appeal on what basis. Both parties will go on appeal. But one thing is that the status quo would likely remain. When you are ousted, you are ousted. The new person that is coming in will sit there and ensure that you can never have a moment to sit in the seat. So I don't see, the court are not messing up the situation, but it's even calming the tempo. The court is calming the tempo.
A quick one. There is this issue of the infrastructural retardation of our courts, where we have the pursuit of justice play out so long because the court system doesn't just have the infrastructure. Talking about things like digitalizing court decisions, which would have helped, because some people would say sometimes you are seeing situations where this court arrives at this decision, this other court doesn't have a clue. And so I'm not as if they should be peeping at each other's decision-making books, but there should be some level of coherency. How do we move this from a talk situation to have our court systems upgrade to the standards that they should be? It shouldn't just be about the increase of 300% of salaries.
It's about the political will, both from the executive and the judiciary itself. You know, when we open up this discussion, most of the times you begin to strike at the executive. There are monies allocated for the basics in terms of facilities. It's about those who are manning the judiciary to also show good faith in it. Allow it that the executive is also not doing enough. You get it? It's not been long ago we heard that even in the Supreme Court, for the very first time, justices of the Supreme Court, Milords, had to protest through a letter that the former CJN was not giving them their deserves. Is that one supposed to be on the executive? No. So within the judiciary, the management should ensure that there is a little improvement in terms of facility. We've been having conferences that begin to expose how the effectiveness our courts can be if we can get digital. And unfortunately, I think the more we preach or the more we advocate, the less we get. But I've seen that even in my state, in Akwa Ibom State, I've seen individual judges who are making effort to ensure that their court is effective, timely, and encouraging for you to practice. They are timeous in the sitting and deliver the judgment on time. I know the one who types as you're speaking, the judge is typing. And he delivers his ruling instantly. They are the kinds. So what should be done now from the recruitment process? Interests of those who are computer literate should be minded to co-opt them into the judiciary.
And even include tools like artificial intelligence.
So the government is aware of this. And just like the recently concluded NBA, we had conference we had in Akwa Ibom State, there are promises from the state government to come in line to ensure that these things are provided. And I'm sure that while we give them benefit of doubt, we give the government the benefit of doubt. After all, the present administration is barely a year and a few months. We cannot begin to say that it will not, because it's in terms of infrastructural provisions. We just need to allow it to take a step.
We are out of time, but I cannot leave you and let you go without asking you 30 seconds. 30 seconds. So we're out of time. 1 minute. The NBA president, chairman, national, just a few days ago talked on the bad governance protest. And he seemed to have been insinuating that the protest lacked merit.
Let me conclude my thought like it says.
Before we have barely
yes,
30 seconds.
I was not in support of the protest. These are reasons. I took part in the 2020 NSAS protest.
Okay.
And I got to realize that a bundle of our protesters are not intelligent and mature enough to protest.
Okay.
Yes, so I think I was one of the first victims. My car was vandalized at Barracks Road. And so I did for no just cause. And we took stock of those who suffered injuries and loss of their properties. They were private individuals. They were our brothers. There are businesses that were shut down completely because there was a protest against police brutality. And the masses took it on fellow individuals, fellow citizens.
Was that the issue of the masses, or was it an issue of the organizer not being able to communicate effectively?
When you call for a protest,
or the police itself
when you call for protest, when you call for a protest, I'm timing us. When you call for a protest, the intention should be well communicated. One, two, those who are moving should be those who knows that we don't need to destroy our community in order to be heard.
Great.
So unfortunately, coming from that backdrop, I was one of those who advocated against the protest. Perhaps in Akwa Ibom State, where I was a victim and I saw what was the level of destruction in Akwa Ibom State. And let me tell you, the government will have to listen to us. Protesting is a right, constitutional right. The court, in this time, the court tried to confine protesters to a particular place. I don't see as that being wrong, because if you unleash them to the street, they will go and what are called talks during elections become hoodlums during protests.
We're out of time. We're out of time. But you've done a phenomenal job today. I wish we had more. I'll bring you back on the program. Anete Basi is a barrister of the Supreme Court, a solicitor of the Supreme Court, a lawyer, a human rights advocate, a negotiator on public affairs analyst. Thank you for being on Political Spectrum today.
My appreciation. Thank you for hosting me. I'll wait your next invite.
Okay, so that's how far we can go today. Be sure to be part of the rest of our programmings and do enjoy your day. Thank you for being part of the program.